Yeah, sure.
Okay, good evening everybody and welcome to our Health and Safety Law workshop and briefing tonight, and thanks very much to the TUCG, to the Institute of Employment Rights and to Hazards who have jointly agreed to co-host and sponsor tonight's event. I'm Fran Heathcote, the President of PCS, and I just want to start by letting you know that we intend to record tonight's event, so please contact us if for any reason you don't want your name to appear in any recording. We intend to run for about an hour, so that should allow time to hear from all our speakers and plenty of time for you to make your comments and questions. So if you wish to raise anything or ask a question, just post it in the chat function and we'll get to as many of those as possible. I'm really pleased tonight to be joined by Steve Headley, by John Hendy and by Janet Newsham, all of whom you'll be hearing more from a little bit later. I just want to start really by making a few opening remarks in relation to my own union, PCS, who, like many other unions right now, are grappling with the quandary of trying to keep our members safe whilst delivering vital services and providing support often to the most vulnerable in society, whether that's through the huge uptake of universal credit claims or the administration of the furlough scheme. So you'll have seen this week that the government are pushing to reopen job centres and reintroduce conditionality and the sanctions regime into the benefit system, which obviously means it's a really busy time for us. The Cabinet Office's official position is work from home where you can and stay safe, but obviously that is becoming increasingly at odds with a government desperate to reboost the economy and return everybody back to normal. So dialogue between us and the Cabinet Office, in other words, us and the other trade unions alongside the Cabinet Office, is becoming more and more frequent, virtually daily in a lot of cases. And we've all had to adapt, I think, to doing things very differently to the way we're used to, both online and virtual meetings, and events like this are becoming our new normal. Our members have many concerns and issues that need our attention, and the importance of being a union member is probably at an all-time high right now. In several of our departments, though, where the employer has tried to instigate a return to work, often prematurely in our view, the legal position is complicated, and we've provided extensive advice both individually and collectively to our members. And so obviously really interested to hear what John's got to say about all of that tonight. To deal with that and facilitate a safe return to work when the time comes, PCS has introduced its own 5 tests: no wider return until communities are safe, workplaces only for essential work, workplaces must be safe places with adequate risk assessments in place, staff must be individually assessed, and outbreaks must be controlled. But the CS of PCS is the commercial sector staff who would have traditionally been civil servants, but their work has been outsourced or privatised. So we've launched a campaign for them as well to defend the temporary gains that we've made for those outsourced workers in our Dying for Sick Pay campaign. Our outsourced workers, many of whom are BME, are already proven to be suffering a disproportionate impact, both in terms of COVID-19, but in terms of low income and worse treatment. And most of them only get SSP, even though they're continuing to provide vital services during the pandemic, putting themselves and their families at risk. And it's simply not possible to survive on that. And it puts an extreme burden on families of these workers delivering vital services who deserve better. As a union, we're very clear that our members, if they're going to be seen as key workers delivering vital services, then they have to be treated properly and rewarded accordingly. And I know as a union we're not alone in all of that. I think it's no good banging pots and pans on Thursdays and supporting key workers if we're going to sit back and continue to accept austerity. We have to learn lessons from what's happening right now and be very clear that there can be no going back and that things are changed forever. There are already discussions within government about continued austerity and about who pays the price of the crisis, and we cannot let this become an argument between big business and life. We have to rebuild and invest in public services so that they're decent, and change the messaging so that the workers who deliver them are valued and properly rewarded. And we have to work for a society that optimises human health. Only by being in a union, working together and standing together can all of that be achieved. And we as a movement have a clear opportunity to fight together in order to change things for the good. By way of opening remarks, we really really are at a time now where if we get this right, our unions can play a key role in all of this. So without any further ado, I'd like to turn to our first speaker. I'm delighted to welcome Steve Headley. Steve's the Assistant General Secretary of the RMT, a union that's always at the forefront of the fight, and obviously we'll all be keen to hear, Steve, what you have to say in terms of reporting back from your union. Over to you.
Hello, and thank you for inviting. Can everybody hear me all right? Can you hear me?
We can now, yes.
I think that's a yes. Well, first of all, I'd like to go into the history of what's happened with the RMT and the transport industry. It was completely unprepared. Oh, you can't hear me now yet. So where did you get to?
That's clearer now.
Hello?
Yeah.
Is this link working?
Do you want to try again, Steve, from now?
That's clearer now. Okay. Okay.
Steve, it's a really bad connection.
Briefly recap. At the start of this crisis, there was at the start, and we had a situation. Okay, all right. Move on to the next speaker.
Okay, we'll come back to you, Steve, and obviously we'll try and get the connection sorted out. Okay, well, I'm really pleased tonight that we're joined by Lord John Hendy, QC, who is chair of the IER, an employment law barrister and a long-standing friend of the trade union movement. John, we're delighted to have you along, and obviously very keen to hear what you've got to say in terms of all of this. So over to you, John. You're on mute.
Sorry, that's right.
Can't hear him either.
Michael, can you unmute him your end?
Sorry.
Michael, try and unmute him at your end. Small technical hitch. That's John. I think you're unmuted now.
I think I am. Can you hear me?
Yes, very clearly.
Okay.
Thank you.
Right. It's unusual for a barrister to be completely muted and out of all control. Right. I just wanted to say a few words about health and safety law. There is a lot of law on this subject, although you wouldn't think so to read the media treatment and the government attitude to the protection of workers against COVID-19. Just to outline it very, very briefly, there's what they call the common law, which is to say the judge-made law of negligence, under which every employer's got a duty to provide a safe place of work, a safe system of work, and safe equipment and a safe staff to do the work. And that's the usual basis on which those who are injured at work or contract a disease at work, or unfortunately have relatives that die at work, sue for damages. But there's also statutory law on this, the Health and Safety at Work Act, of course, of 1974, and regulations which are made under it. Now, those regulations are very important in relation to COVID-19. There's a duty under the workplace regulations on employers to keep workplaces safe, to provide washing facilities and so forth. And that includes the duty to keep surfaces clean. There's a duty to provide personal protective equipment. And there seems to be some misunderstanding about this on the part of the government. The duty to provide personal protective equipment is a duty which exists in all circumstances where risk cannot be eliminated by other means. So it's all very well saying we want social distancing and lots of hand washing and so on. But if that doesn't eliminate the risk, and I mean eliminate, that's to say there's no significant risk after those measures have been taken, then there's a duty to provide personal protective equipment, which in this case would be in the form of masks, maybe face coverings, maybe gloves, maybe gowns, depending on the type of work that's being done. Other regulations deal with dangerous substances at work, which would include the COVID virus. That's the so-called COSH regulations, control of substances hazardous to health. And there's also regulations which deal with the reporting of accidents and diseases at work, the RIDDOR, so-called RIDDOR regulations. And that includes a duty on employers to record incidents of COVID-19 contracted at work. Of course, it's not always easy to determine whether coronavirus has been contracted at work or it may have been contracted in other circumstances. But that's one of the problems with the prevalence of this disease. Now, the problem with those regulations, all those regulations, is this, that in 2013, the Tories and the Liberal Democrat coalition government changed the law so that you couldn't sue, you couldn't bring civil proceedings for breach of those regulations. Absolutely unforgivable change. It was noted at the time by academics and by unions, but nothing was done about it. But the fact remains that breach of those regulations is a criminal offence. And it's very, very important for those who are health and safety representatives or trade union representatives to know that breach of those regulations is a criminal offence, and employers ought to be in fear of prosecution. The problem, of course, arises because we all know that the health and safety executive has been starved of funds over the last 40 years, and in particular over the last 10 years, and so have local authority environmental health inspectors, to the extent that there's less than 600 inspectors to inspect some 1,700,000 premises that fall within the local authority sphere of operations. And that includes offices, shops, warehouses, and so on. So the powers that the inspectorate have to inspect, to take measurements, to check up, and so on, and where they find breaches, to serve an improvement notice or a prohibition notice, or to prosecute for a criminal offence, have become more or less meaningless in relation to this pandemic. Those powers are simply not being used. When I last checked this, I couldn't find that there'd been a single improvement notice, prohibition notice, or prosecution brought for breach of the regulations in relation to coronavirus. It may have changed over the last couple of weeks, but that was certainly the situation up until a couple of weeks ago. Nevertheless, health and safety reps and trade union officers can mount the arguments that the regulations are being breached, and these are powerful arguments in the course of negotiations over what is going to be safe at work. One of the difficulties that we're confronted with is that the government advice on return to work, of which there's 8 dealing with each sector, advises employers not to use PPE in the form of masks and so on. I mean, in my view, that's simply wrong. I mean, it all depends on the nature of the workplace, of course, but that advice seems to me to be wrong. And it may be that it's based on a mistaken understanding by Public Health England and indeed the World Health Organization that coronavirus can't be transmitted in the air by way of aerosol and only by droplets. But those who read The Guardian will have seen this morning that a whole bevy of experts from all over the world have challenged that and said that coronavirus can be transmitted in an airborne form. And that means that, of course, where you've got workers in a confined space, whether it's a small office or a small shop where there's not constant changes of air, they are exposed to serious risk. And of course, I note that this very week, and I'll be taking part in the debate in the House of Lords, this very week, there's a debate about a statutory instrument which makes it a legal requirement for travellers on the railway to wear masks. And one asks the obvious question, well, if railway passengers are required to wear masks in the confined spaces of railway carriages, why aren't workers in confined spaces required to wear masks? And I think that's a powerful argument that ought to be used. I'm very conscious of the time, Chair, so I'll just leave off by mentioning two final matters. One is that, as all trade unionists know, Section 44 and Section 100 of the Employment Rights Act entitle workers not to be subjected to a detriment or dismissal where they have refused work because they believe that they are in imminent danger. And I'll just read to you the words of the section, because if you don't put it in legal language, it's likely to be misunderstood. It says, circumstances of danger which the employee reasonably believed to be serious and imminent, and which he could not reasonably have been expected to avert. So those are the conditions for a legitimate refusal to work without any detriment, with being entitled not to have any detriment against the worker imposed because she refused to work. A serious and imminent danger. Now, nobody could doubt that coronavirus is serious. The imminence of the threat depends on the circumstances of the workplace. The lone tractor driver ploughing a field is not likely to be in such circumstances. School teachers in a small classroom with 30 kids in them might be in a very different situation. So workers do have rights to refuse work, probably best in the threat rather than actually waiting to be subject to a detriment or being dismissed for it and waiting for 2 years for an employment tribunal. Because that's another problem we've got over enforcement, that tribunals are not sitting, hearing substantive cases, which means that workers are going to have to wait a very long time to have their claims adjudicated and to get any compensation from it. But there are legal arguments, and I think that's the best I can say to those who are listening. There are legal arguments. Use them to the best of your ability to try and negotiate safe conditions to work, because nobody should have to work in an unsafe environment. Thanks for listening.
Okay, thanks so much, John. And obviously that's covered quite a lot of ground, and clearly there's a lot of comments in the chat that you've obviously rung bells with a number of people in what you've said. Should we try again to get Steve Headley? Steve, are you going to try again?
Yeah, okay.
That's much clearer. Yeah.
Is that better? Okay.
Yes.
All right. So first of all, I'd like to say that the government were completely unprepared for this in the transport industry. We had a ridiculous situation where just before lockdown, and indeed well into lockdown, we didn't even have basic PPE on trains or in stations. There was no masks, no visors, no gloves. In a lot of cases, there wasn't even any hand wash. So I think that the spread of the virus up and down the country probably was expedited by the absolute lack of preparation that the government had put in. And I mean, it wasn't as if they didn't know it was coming. I mean, other than getting a postcard from China saying that the virus is on the way, I don't really know what other form of communication or warning they would have wanted. But we've been in lockdown now for about 3 months on the railway, and people are only supposed to be having essential travel. As you can see, that's not really been the case, because in places like the seaside places like Bournemouth, we've had packed trains. A lot of the time, passengers have been ignoring the instruction to wear a mask. That's only been brought in the past few weeks anyway. Until then, there was no compunction on passengers to wear masks. At the minute, the social distancing is still supposed to be 2 meters between customers and passengers. But what the Railway Board, the RCIF, are now saying that the Rail Coronavirus Industry Board are now saying that they want the distance between passengers to be 1 meter plus, but the distance between workers, they still maintain at 2 meters, and the distance between workers and passengers to stay at 2 meters. Well, that's obviously a dog's dinner. I mean, it's not going to be maintainable. If everybody thinks it's a meter, then people will be coming within a meter of staff. I mean, they won't understand that they've got to stay 2 meters away from staff. To pick up on what John Hendy said, I mean, we have had instances where we've said that people have refused to work on serious and imminent grounds of serious and imminent danger. I have to say though, like a lot of unions, our union was very slow in getting that information out. That's people's legal rights in any circumstance, and we should have had that out a lot sooner than we did. Unfortunately, we didn't have that out. But we're now approaching a kind of crunch point, because a lot of the
Steve, you're frozen again.
are now saying that they're going to be laying off unless we can get on that. Have I gone again?
No,
How's that? Is that better?
That's better. That's clearer,
right,
yeah.
Right. Okay. I'll turn off the video. How far did you get? Did I get until the employers want to ramp up the numbers again?
That's just where we got to, yeah.
All right. Okay. So in order to ramp up the numbers again, they're only running at about 15% now, and it varies in different places, because to complicate things even further, we've got regional variations. Scotland's different, Wales is different, England's different. So you've got until recently you had to have a mask to travel on a train in Scotland, but once you got into England, you didn't have to have a mask. So our members were supposed to police these kind of systems where you different rules and regulations in different places. But now what they want to do is get as much services and as much people onto the trains as possible in order to increase their revenue. That's a management view, and their kind of stick they encourage us to cooperate with this is that they said, well, they're going to have to make mass redundancies unless it happens.
Steve, you're broken up again.
Unless they can provide, for example, catering, they're threatening to delay thousands. Is it? I don't know. The employers are threatening to have mass redundancies in the catering grades. Already on the select service partners around the stations, we've had thousands of redundancies. And they're saying that unless we can work together to find a method of work that's safe and an agreed risk assessment, then they're going to have thousands of more redundancies on the onboard catering on the trains. And I think that we will be working with them. We will be entering the process, but ultimately we will be maintaining a veto on that, because if there's no safe system of work available, then we'll be telling our members not to be working, and the chips may fall as they will, but we can't be in a situation where we're endangering people's lives. So I think that all in all, we've come through this pretty well on the railway and in other industries. We have had massive problems in London with bus drivers, but they've been Unite members. Not very many RMT bus drivers in London, but yeah, I know there's about a score of bus drivers who've probably lost their lives that we know about, and the TfL were very tardy in introducing safety measures there, and the mayor has been an absolute disgrace, terrible, and when bus drivers took things into their own hand and refused to let people in the front door, then the mayor put out an instruction through TfL that would have to be stopped and both doors would have to be open. And only later did he actually turn around and say, well, we'll have the front door taped off and people can use the back door. So politicians of whatever hue haven't been good on this, neither on the national level or in a London-wide level. And the ramping up of services, I think, if people take to the trains, I think it's inevitable that there will be a rise in the people in the number of people taken, in the R number and the number of people being infected. But at the same time, if steps aren't taken to up the capacity on trains, the amount of people using trains, we fear that there's going to be tens of thousands of redundancies just around the corner. So we're between a rock and a hard place. We want to get the service back as soon as possible, but we want to do it safely. We think essential travel has to happen, travel for work, travel for medical reasons, and other essential travel. But what we don't want is what we've seen at Bournemouth is thousands and thousands of people. I think it was 500,000 went to Bournemouth on a particular day. Most of them without masks or PPE on crowded trains. And that's the situation we want to avoid. So I think that's about sums it up from where we are as a union.
Okay, thanks so much, Steve. And obviously, sorry we lost you a bit in the middle, but I think we got
No worries.
That's great. Thank you. I'm going to invite Joe Simpson, who's the Assistant General Secretary of the POA, who's also going to say a few words. So over to you, Joe. While Joe's just waiting to come in, can I just remind people, if you have got questions, if you just put them in the chat function, and we'll get to as many of those as possible. Just keep posting there. I see that John Hendy's actually answered a couple of the questions that people have posted in there, so just keep your eye on the chat function, and I'll hand over to Joe next. Okay.
Hi, Fran. Thanks very much.
Thank you.
Been listening to John, listening to Steve as well. I mean, the POA are in a very, how can I say, dubious position when it comes to this, because we are banned from even thinking about taking any action, to the point where we had a situation in one of our prisons at Lindholm at the beginning of the year where the governor was putting our members' health and safety in well, serious jeopardy, really, because we were averaging 6 assaults a day in the prison of our members. So our members decided to that they wanted to move to a place of safety, which they did, and off we went to court. We were found guilty of breaching the injunction, and we were also told that if we didn't bring our members back in, that they were going to start looking at sequestrating our funds. So Section 44 was wasn't having the effect for our members as what we thought we had. So anyway, we went to court, and thankfully they decided to settle out of court. So we now have a protocol which is based around Section 44 for our members. So that served us quite well with COVID, because we have told them if you can't maintain that 2 meter distance for our members, then we want PPE. And what they'd done was absolutely shut every prison down, and I mean shut it down. You know, we're going back to what I used to term the bad old days, but prisoners weren't locked up for 23.5 hours a day and 23 hours a day. Prisoners were getting out, they were getting access to fresh air, they were being access to showers. The only thing that we couldn't give them was visits with the loved ones, and that's because the prison service is so far behind with the technology in prisons. So as government decided they were going to start and lessen the sanctions out in the community, we had to look at what we were going to do in prisons. And it was just like a headlong rush by individual governors that they wanted to get visits on, they wanted to get education on, especially in the young offenders prisons, because given education to young offenders is covered under statute. So we have to provide that. So then we had to start dealing with the unions, UCU, to start and look after their members as well, because governors weren't giving them the PPE to come into prisons and start having face-to-face education classes, which they had been providing, but obviously with the PPE that we had. So really, we're starting to slowly open. The problem we have is the PPE situation, because we keep getting informed that government are going to come along and say, we're going to reduce it from 2 meters to 1 meter. We've told the prison service that isn't happening in prisons. It's 2 meters, and if we breach that 2 meters, you've got to give us PPE. They understand that, to the point where they don't want to test that protocol that we've agreed with them in court, because if they do breach it, we can then go for injunctive relief against them for breaching our members' health and safety. They are also frightened of, because the one thing that we can't do, we can't say to our members, well, if your health and safety is in danger, you can walk out. What we have to inform them is the law says that if you believe your health and safety is in serious and imminent danger, you can withdraw from the workplace. But that has to be your decision. That's where we are in prisons. But at the moment, I've got to say, from the top, they're behaving like a responsible employer.
Yeah. Okay, thanks, Joe, and that's a really useful update. So clearly we've got a range of different experiences across different sectors, and John, you'll be tasked with trying to provide answers to some of the many and varied questions that are coming in. So if I start by reading you out the first couple, and then probably if we just take a couple at a time, give you a chance to respond, and then see how many we can get through. As I say, if you have got questions for John, keep them coming into the chat function and we'll pick up as many as we can. So starting off then with Oliver Pereira, who wants to know why teachers are being treated differently when it comes to wearing PPE. The DfE have said that it doesn't apply in schools. And then Tracy Edwards saying, what is the legal position regarding people working from home? We know that the Health and Safety at Work Act protects you in the workplace. How does this extend to home working? My understanding is it may be a grey area, and I'd be grateful for any thoughts that you had, particularly if your contract of employment does not state your home as your place of work. So clearly not a contractual home worker, but somebody who is working from home during the crisis. So John, I don't know if you want to start with those couple, and we'll pick up some more.
Yeah, I see there's several questions about the situation in schools. Somebody asked me also whether school children should wear masks. The answer to that is, well, if the PPE regulations apply, they only apply to employees and not to school kids. But whether teachers should be provided with masks is a different question. I know the employers have said that they're not necessary, but the question is whether the risk can be eliminated by other means. And I would have thought that's pretty dubious. I mean, I suppose there may be some very spacious schools with air conditioning, changing the air 6 times every hour or something like that. But I would have thought that most schools haven't got those facilities and are in relatively cramped conditions with a lot of people in the same room, breathing in the same air for 3/4 of an hour at a time, and without not maintaining 2 meters, and probably not having washing facilities or cleaning facilities in between lessons. So I would have thought there's a very powerful argument for teachers to be provided with PPE. I mean, it's something really that ought to be addressed by the union rather than individual teachers or even individual branches of the union. One of the things that would be very important in order to either bring a case or persuade an employer is for unions to do their own risk assessment. And there are plenty of possibilities for a risk assessment, just looking at the measures that are taken, the particular circumstances of the school and the teaching program, and so the timetable and so forth, and assessing what the risks are and what measures are necessary in order to eliminate that any significant risk of contraction at work. As to home working, well, employers do have a responsibility to maintain a safe workplace or a safe place wherever anybody's working, but obviously their control over the situation at home is a lot less. And if people are working at home not at the direction of the employer, it's a bit more difficult. I mean, if you trip over your own electrical cable, run into your own computer, it's going to be pretty hard to bring a case against the employer for that. Likewise, possibly if you contract coronavirus from somebody that you live with, it's going to be difficult to show that that's the employer's fault. But I'm afraid it's you know, a typical lawyer's answer, how long is a piece of string? It all depends on the nature of the risk that you envisage and the circumstances in which, of your home, and the circumstances in which you are actually working at home. With your agreement or under compulsion, does the employer provide the equipment, or is it your own, and so forth and so on. So I'm not going to be very helpful on that one. Should we look at another couple?
Yeah. I mean, I see you've addressed some of the ones that have been raised. Certainly Kevin's question early on about section 44. I think Kevin McNerney, you came back with an answer to that, so that's helpful. And then Heidi had a question from PCS. The employer states that they're of the opinion there is no imminent risk because they provided distancing and sanitation. How do we argue section 44 within that stance? And I think you have replied to that, John, I believe. Yeah, so that's great. Sharon Law, sticking with schools, we've got a couple more questions. How does health and safety affect schools? The government is saying no distancing and no PPE in September. And then Marie Monaghan, on the same theme, says government advice issued last week for further education sector has introduced a new PHE endorsed system of control. The guidance claims that if you meet their guidance, you are compliant in all areas. This obviously clashes with the hierarchy of risk reduction, MANREGs. Any comments on this would be helpful. I don't know, John, whether you can shed any light there.
Yeah, I don't think one should necessarily accept the guidance of the PHE or the government at face value, because the circumstances are different in every workplace, and what's required is a proper risk assessment. I don't think either that trade unionists should necessarily accept the employer's risk assessment. They should consider getting their own risk assessment. Yeah, I'm not sure I can say more about it than that.
No, okay, thank you. And I appreciate I'm sort of firing these at you a bit, so, you know, take your time. But Mick Jenkins asks, if staff go home because it's not safe to be at work, for example, because it's impossible to maintain a 2-metre gap, are they still entitled to be paid?
Yes, they should. They should be. It's not their fault that they're leaving work, but I mean, obviously, you want to be absolutely sure that you can demonstrate a serious and imminent danger from COVID-19, and you've got to have a reasonable belief that you're in serious and imminent danger. So, you know, you need some compelling evidence.
Okay, thank you. Antonia asks, will unions fight to keep jury trials? I've heard that these are under threat currently to clear the backlog of cases built up due to COVID, but it can lead to huge miscarriages of justice, which means the anger and frustration of injustice and jointly adding to racism in the system. So that's quite a loaded question there, but I don't know if you've got views on that, John.
Yes, certainly. There is a proposal to do away with jury trials. The government hasn't made a decision, but I think it's very important for trade unions to stick up for jury trials. We know it's one of the elements of democracy that ordinary people can sit on juries and decide whether somebody's guilty or innocent. And it is one of the, I was going to say, few benefits of British justice, but whether it's few or many, it's certainly an essential element of justice, and we have to fight to maintain jury trials.
Okay, thank you. Caroline says, does anybody agree that the pandemic gives us a really great opportunity to campaign for the unforgivable changes to legislation in 2013 that were referred to by John Hendy? So, you know, John, I think you've already said that that's something we really need to challenge and fight against.
Yeah.
Yeah, okay. Colin Tate, PCS, how do you eliminate the risk from members of the public visiting visitor attractions if the government guidance does not state that visitors should wear them, should wear PPE presumably? And I don't know, that's an easy one to answer, because in the case where those attractions remain open, what Colin's asking is, how do you eliminate the risk from members of the public? And I suppose the short answer is it's very difficult.
Well, I would have thought so. I mean, the operators of attractions have got legal responsibility to look after their visitors and keep them safe. But those duties are not as clear cut as the legal duties on employers to employees.
Right, okay. Thank you. Steve Ballard asks, is there any legislation intended to safeguard employees' occupational health that could be invoked under the current circumstances?
Well, I did mention them at the beginning. Yes, there is legislation which can be invoked. The PPE regulations, the COSH regulations, management at work regulations, and so on are very relevant. And they're worth Googling. They're worth looking up. They're quite easy to read. And the duties are spelled out very clearly in them. In fact, I did a note for the trade union campaign group, which Michael Calderbank has got, which I'm very happy that he should circulate to members of the campaign group.
So it might be worth trying to get hold of that then, John, and that's
certainly, yeah.
Circulate. Okay, thank you. Okay, next one from SWD then. Should not school support staff who prepare and handle practical equipment be treated as an additional case on the issue of PPE? So often they're overlooked, but quite exposed in their normal day-to-day functioning. And
yeah, absolutely. Support staff should be as equally well protected as teachers, and so should cleaners and all, what should we say, ancillary staff that look after the main business of the enterprise, whatever it is, maintenance people and so forth and so on. They're all workers. They should all be protected. There is one wrinkle here, which I don't want to spend time on legal technical matters, but the statutory duties only apply to employees and not to people who are self-employed, or what the lawyers call limb-B workers. But all those regulations are derived from EU directives, and the EU directives do apply to all forms of worker. And there is a case being brought at the present time about whether the PPE regulations should apply to non-employees who are working for the enterprise. So we look to see what the result of that case will be.
Okay, thank you. Ian Perring, Trade Union Side Safety Officer and Health and Safety Rep for the Palace of Westminster for PCS, said, what about Section 3 of the 1974 Act in regards to school children, as the purposes of the Health and Safety at Work Act 1974 include protecting people other than those at work from risks to their health and safety arising out of or in connection with the activities of people at work, i.e. from teachers and staff. So I think that's partly what you've already covered, but just whether or not we can use Section 3 of the 1974 Act.
Yeah, the problem with sections 2 to 7 of the Health and Safety at Work Act is that they never were enforceable by civil proceedings. Only the regulations made under the Act were enforceable. And as we've noted already, that right was taken away in 2013. So Section 3 is a statement of legal duty, but it is in fact, there's no mechanism by which it can be enforced. However, that duty is the same as the duty in negligence. So if a school kid contracts coronavirus because the school has failed to take adequate precautions against it, the parents of that child on his or her behalf could bring legal proceedings for a breach of the law in identical terms to Section 3, but it would be under the common law. Hope that's not too technical. Sorry about that.
Okay, thanks, John. Adarsh Sood asks, if the employer does not include travel to and from work as part of the individual risk assessment for each employee, what rights does that employee have?
That's a very difficult one. I mean, if a worker is in a train which has a train crash on the way to work, obviously the employer wouldn't be responsible for it. But since employers know that people are coming by public transport, I suspect that the answer is that employers are entitled to assume that the operators of public transport, in spite of what Steve has told us this evening, that the operators of public transport are taking the necessary precautions, and therefore it's not the responsibility of the employer if somebody contracts coronavirus on their way to work.
Okay, thank you.
I think it's a practical issue rather than a legal one, really. I just can't see that a court would hold an employer liable. But very different, of course, if the employer is providing the transport, as many do, for example, a minibus or something where people are crammed in and there's no social distancing or other measures available, then the employer would be liable if you could demonstrate that the disease was caught because of the transport.
Okay, just for information, everybody, Michael Calderbank has now shared that note for trade unions that John referred to in the chat. So if anybody wants to, you can access it there and download it from there as well. So that's helpful if anybody wants that. Okay, John, just a couple more. We're getting there. John Burgess asks.
What about Janet? Surely Janet wants to speak.
Oh, I'm coming to her next. You'll get a breather in a minute. Does John where's that gone? Does John know if Health and Safety Executive have taken any enforcement action against any employer to date?
I think I mentioned that in my opening. I'm unaware of it, but I had confirmation that no case had been taken up to about 2 weeks ago, and it may be that some have been taken since, that I'm not aware of.
Okay. Okay, well, John, you've done a sterling job, because I realise I've been sort of throwing them at you thick and fast. And as you say, we have got another speaker, and we're going to hear next from Janet Newsham from the Hazards campaign. And Janet's going to give us a bit of an overview about the work, the really important work that they've been carrying out. So Janet, over to you.
Thank you very much. And thank you very much for asking me to speak. And it's been really interesting listening to your questions and the responses. So we're a Hazards campaign, which we're a campaigning organisation on health and safety. And from the beginning of this pandemic, COVID-19 has been centred in workplace health and safety, and it's highlighted the inadequate protection for many working people against the risks at work, and how the inequalities in society have increased workers' exposures to the risk of infection. There's been systemic failures in our occupational health and safety laws to protect workers and prevent harm, and UK workers have been placed at significant and unnecessary risk throughout this pandemic. And it's clear that we can't trust the UK government, Public Health England, or the Health and Safety Executive to protect workers and public health. And workers' health is public health. An increased risk in workplaces has been shown to spread the virus and places communities in jeopardy. Leicester and Anglesey have been recent prime examples, but that's nothing new. There's been many examples of individuals and communities placed at risk because of unsafe and unhealthy working conditions. Health and safety laws was developed over decades, and it's been fought for by the collective action of workers. But for the last 3 decades, health and safety has been ideologically demonised as pointless red tape and a burden to business to undermine its effectiveness. All the things that keep workers safe and healthy. Health and safety laws, enforcement and trade union organisations have been attacked and undermined by deregulatory neoliberal governments of all shades, and funding to the enforcement authority has been cut by more than 50%. The introduction of new laws have been prevented, and workers' ability to get compensation or redress has been denied. There's been an insatiable drive to cut regulations, the very ones that protect workers, our communities and our people. Steve Toombs, in his Better Regulation, Better for Whom, says business harms are routine, systemic and crucially avoidable. They are a form of violence so widespread they've been called social murder because they put communities, consumers and workers in a position that they inevitably meet a too early and unnatural death. Last year, before any sight of the pandemic, the Hazards campaign produced a manifesto for a health and safety system fit for workers, decent jobs and decent lives. Read it on the Hazards campaign website. We need a sustainable solution to our broken health and safety system, a system that's continually resulted in the deaths of more than 50,000 workers every year, numbers equating to nearly 2 Grenfell Tower tragedies every single day. Before the crisis, many of the very same essential workers regarded highly through the pandemic were trying to survive on insecure 0 hours contracts, poverty wages, sleeping in unhealthy housing, or even in cars, or on their friends' floors, or in tents outside workplaces because they couldn't afford to travel to. Workers were sacked for taking too long on the toilet, being taken away in ambulances because they were too scared to call in sick with life-threatening conditions. Workers peeing in bottles or shitting in plastic bags because they didn't have the time to move from the workstations, or they didn't have the welfare facilities available to them. Rory O'Neill in the Hazards magazine said that workers should not be disposable and work should not be spirit-sapping, body-breaking grind, and warned that bad jobs are driving us over the edge and it is time to turn and fight for basic decency, security and rights at work. Health and safety is an equality and class issue. Who lives and who dies is not an accident of chance, and virtually all health and safety risks go up as pay goes down. From stress to dust exposure to heavy work, to heaving heavy loads, low pay increases your blood pressure and our work stress and eventually can kill us. The care workers that were exposed to the virus with no personal protective equipment are not the ones that could work from home. Many have been abandoned to life-threatening fate, and one that many have sadly lost, and for most, one that wasn't even thought important enough to count. To create a health and safety system fit for all workers, the heart of decent jobs and decent lives, we need an end to the deregulation agenda and to restore regulation and enforcement as a social good. We love red tape. It saves lives and health. We need a health and safety system that's based on prevention, precaution and participation, and a fully funded independent health and safety system with strong laws, strict enforcement and empowering trade unions to stop workplace harm. We want just treatment to the victims of health and safety crime and ensuring fair treatment for all workers harmed by work. It needs to be called out. Don't describe workplace injuries and deaths as an accident. For the vast majority, they are foreseeable and preventable. Our employers are injuring us and killing us. I work alongside Hilda Palmer, one of the fact giants, Families Against Corporate Killers, who works tirelessly to support families of people who've been killed by work. And we want full compliance with the highest standards of health and safety law. We need real enforceable employment and safety rights to ensure good health and safety in precarious work, with enforcement agencies working together. We have to hold government, employers and the enforcers to account. When workers are killed through negligence, then all those responsible must be brought to justice. We should never have had the criminal negligence of employers unable or unwilling to provide the precautionary level of PPE necessary to work safely. And if this is the fault of government, through its agencies, reduce its standards which expose workers, then they too need to be held to account. We need to campaign to increase the fines imprisonment of all those responsible from top down. We have continually seen political interference in our enforcement and public health bodies through the pandemic. It's been shown to be blatant and places workers' lives secondary to the profits and economy. Nothing changes. The only real protection that workers have is being in an organised trade union, an active trade union, which collectively acts to protect and enhance workers' conditions. Trade union reps are our heroes in the workplace. We know that where there's an organised and active trade union safety organisation, then workers are twice as safe. So I wish I could end with when this is all over, but this may never be all over. This may be a new reality, and therefore unity is strength and all we ever had. And we need to organise and act collectively to achieve decent jobs with a real living wage, secure employment and a system of health and safety that takes a precautionary and preventative approach, and one that's proactive and participative. Please support the Hazards Campaign Manifesto and work with us to improve and strengthen our broken health and safety system. Support our campaigns and take them into your trade unions. For the betterment of society, we need decent jobs, decent lives and a health and safety system fit for all workers. Thank you.
That's great, Janet. Thank you very much. And, round of applause to you virtually, because I think, that's really pulled together a lot of what we're trying to get across. I recognise that we are running out of time, but I think the Hilda Palmer has posted links to the Hazard Campaign and to the website in the chat. So if people want to go and have a look at that, I would urge you to do so. In terms of the time, I'm just going to invite our two speakers, Steve and John, if there's anything they want to say in closing, a message to sort of take away with people now, if you like. So Steve, anything from you? Steve Headley?
I'm muted. Sorry.
Oh,
I'm
yeah,
muted.
yeah.
No, that's fine. I just hope that people picked up enough of what I've said on the really bad connection.
Okay, that's great.
All right.
Thanks,
All right.
Steve. Yeah, we've got you. And John, over to you.
Well, just to say that the way forward is obviously through unions, through negotiation, and through collective pressure. The law provides some useful arguments for us, but it's only collective action that's going to make anything really happen.
Yeah. Okay, well, thanks very much. And thanks to everybody that's contributed tonight, because obviously this is such a huge topic and every sector has a slightly different experience. It's great to see so many unions represented on the call, and I hope that you've managed to get something out of what's been said, that you've been able to listen to the advice given by John. I mean, feel for John, because I literally threw questions at him from all over the place and he was able to respond. So thank you very much for doing that. And can I just wish you the best in all that you're doing in terms of representing your members, everybody, because I recognise what a difficult time this is for trade unionists. But I think, as we've outlined throughout the call, there are some real opportunities for us here, opportunities for us to join our campaigns together, to link up in terms of the challenges we face, and as John said, to use the law that the legislation that we've got to challenge some of what's going on, and we should, if we all work together, be able to come out of this stronger in the long run. So I recognise these are unprecedented times and that everybody's got an awful lot on their plate, but I hope that you found this evening useful and that we'll be able to do more events like this. So thank you very much for your time, for your input and for your contributions. Stay safe, everyone, and no doubt speak to you all soon. Thank you.